Hello everyone and welcome to the second of our video tutorials on voluntary manslaughter. Today we're going to be looking at loss of control, which comes from the Coroners and Justice Act 2009, section 54. I'd like to start by just reminding you of the three different homicide offences, just so that you can see where loss of control fits in here. We have murder, voluntary manslaughter and involuntary manslaughter. We've already studied murder, where the actus reus is the unlawful killing of a reasonable person in being unto the Queen's peace, and the mens rea is malice aforethought express or implied, meaning intention to kill or cause GBH. In our last video tutorial, we were looking at voluntary manslaughter, diminished responsibility. And this is where, although the defendant had the actus reus of murder and the mens rea for murder, they had the partial defence of a mental abnormality. Today we're going to look at the other type of voluntary manslaughter, which is loss of control, and this time again they meet the actus reus and mens rea of murder, but we're saying that they killed out of anger or out of fear. Our other type of homicide is involuntary manslaughter, which we've not studied yet, but this is where there is a killing, the actus reus of murder is met, however, they don't have the mens rea for murder. So today we're going to look at our second type of voluntary manslaughter, which is a partial defence, loss of control. Loss of control is a defence which replaced an old defence called provocation. If loss of control is successful, it works just like diminished responsibility. It means that it reduces what would otherwise have been murder to voluntary manslaughter. And so instead of having mandatory life for murder, they can have discretionary life for voluntary manslaughter. The defence is set out in section 54 of the Coroners and Justice Act. Look at the elements you have to prove in order to successfully plead loss of control. It is important just to bring your attention to the old defence of provocation, which this defence replaced, so that you can see whether in fact there is an improvement on the law. So the old defence of provocation was one of the most controversial elements of the criminal law of England and Wales before it was changed by the Coroners and Justice Act. There were many criticisms of the old rule on provocation, which led to its alteration. And you might get asked a question on the exam, has loss of control improved the law here? So that's why it's important to know about the existence of the old defence. Provocation was an ancient defence developed in the 16th century, and the reason we've got this particular image on the slide is that it was actually created where to cover situations where typically a man found his wife committing adultery, and out of anger, in a fit of rage, he would kill the lover, his wife, or both. And in the 16th century, we developed this idea of provocation, that you were provoked to kill. And over the years, provocation later expanded to include some really ridiculous cases where men were able to use the defence of provocation to claim that their wife's constant nagging caused them to lose their control, and in such cases, the sentences were often remarkably low. Another big problem with the law on provocation was that because it was made by men, for men really, it was based on typical ways that men react. So people were able to plead this defence if they experienced a sudden snap, like men typically do as a result of being provoked. But if the defendant experienced more of what psychiatrists call a slow burn, they weren't able to plead the defence. And this was one of the difficulties that battered women faced, was that the law was very slow to recognise a defence in cases of a slow burn action. Rather than lashing out in anger in response to a specific incident, some battered women will accumulate pain and torment, and they'll only exhibit violence sometime after the provocative incident as their domestic life becomes unbearable. So where the law on provocation sympathised with men snapping in a rage upon their wife having an affair, but it wasn't catering for women who were eventually driven to kill after years of torment. So we will refer back to provocation as we go through looking at loss of control to see how the defence has changed the law. In order to plead loss of control successfully as a defence to murder, there are three elements. We have to show that the defendant suffered a loss of self-control, the loss of control had a qualifying trigger, and a reasonable person might have reacted in the same way. And it's important as lawyers we try and remember our section numbers for each of these requirements. As always, we're going to look at each in turn with some cases that helps to illustrate how they work. First requirement is that we have to prove that our defendant killed because they'd lost control. Now, section 54 subsection 2, loss of control doesn't need to be sudden. So we're going to refer back to an old case now, the case of Ahluwalia, and this was an old provocation case, but it's relevant to look at here. You can see this case is 1992 and we only got the defence of loss of control in 2009, so it predated the defence. This is a picture taken from a film that was based on the case. This is from the film Provoked, and it was based on the true story of Karinjit Ahluwalia, who suffered years of abuse at the hands of her husband. So she suffered for many years violence, abuse from her husband, including rape, including an attempt to kill her. And on one particular evening, her husband threatened to attack her. That night, while he was asleep, Karinjit Ahluwalia poured petrol over his feet and set them alight. And she said that she did that because he regularly burned her and she wanted him to feel the pain of burning. The husband died from the burns he received some days later. She was convicted of murder and she appealed, trying to plead provocation, i.e. that she'd been provoked to kill him. Now, back then, before we had our new defence, her claim failed because the defendant's reaction was not sudden. And years ago, for provocation, you had to suddenly snap. And because she'd suffered years and years of abuse, what we call cumulative provocation, rather than one single event, she was unable to plead it. However, because we now have the 2009 defence of loss of control, the section clearly says it doesn't need to be a sudden loss of control. So it's very likely that defendants in situations like Karinjit Ahluwalia now would be able to use the defence of loss of control because it does allow for a short lapse of time between the last provocative act and the killing. Having said that the loss of control need not be sudden, it must be stressed that it shouldn't look like revenge. The defence of loss of control won't allow a revenge killing. Okay, so case of Ibrahim and Gregory, again, it's an old provocation case, but the same principle will carry across. So here, there was a killing 5 days after the last provocative act. That was said to be too late, and that showed a desire for revenge and was not allowed. So if something happens to you which makes you furious, and you wait 5 days and then kill them, you are likely not to be able to plead loss of control because although it need not be sudden, if it's 5 days, it looks like revenge. So we're going to compare the case of Ibrahim and Gregory to the case of Bailey, which is also on the issue of revenge. It's helpful to look at the facts of this one to make it clearer. So our defendant here was a dad, and his youngest son told him that a drug dealer had been supplying all of his sons with drugs and had threatened to kill them. The dad went into a rage when he discovered this, armed himself with a shotgun and a razor, drove immediately to the dealer's house, and he killed the drug dealer. And again, he was trying to plead the defence of provocation because, again, it was before we had loss of control, but the same principle will carry across. Here, unlike Ibrahim and Gregory, the defendant Bailey was allowed the defence of provocation because although there was a time lapse, i.e. between his son telling him and him shooting the drug dealer, the court decided that there was no time to cool down. So if you imagine the situation, he's just been told, he runs around the house, he grabs his weapons, he gets in the car, he's still furious, seeing red, even while he's driving round there, and then he kills him. So another phrase for this is reason must not have had time to resume its seat. So if the person is very het up still at the time, it is likely that they're going to be able to plead loss of control, but we won't allow revenge, which is days later when they've cooled off. To prove that there was a loss of control and it wasn't revenge, you have to show there was a qualifying trigger. Now, there are two triggers that you could plead. Sometimes you might have both, but usually it's one or the other. So the fear trigger is that the defendant has lost control and killed because they fear serious violence from the victim against himself or another identified person. So that would cover defendants like Karinjit Ahluwalia. She killed her husband because she feared serious violence from him to herself and also probably to her children as well. The alternative is the anger trigger. And this is where you're not killing out of fear, but anger. And you are angry because things were done or said, or both together. And these were circumstances of an extremely grave character and caused the defendant to have a justifiable sense of being seriously wronged. So it's not enough to just show you've been angry, because of course we all get angry, me every day. But in order to kill someone and have a defence, it has to be extremely serious and give the defendant a justifiable sense of being seriously wronged. We'll have a closer look at both of these. So the fear trigger is quite straightforward. The old defence of provocation didn't allow for a loss of control out of fear, which was another big criticism of it. So husbands could kill their wives out of anger, but a wife couldn't kill their husband out of fear. So loss of control has improved that area of the law, and now battered wives such as Ahluwalia could be able to use loss of control if they're in fear of serious violence from their partner. The anger trigger, though, has some controls on it, so it's got to be of a serious nature and give you a justifiable sense of being wronged. And this is another improvement on the old defence of provocation, because in the past, if we look at the case of Doughty from the 80s, this was a provocation case. In the old days, provocation was allowed and there weren't any controls on the trigger. So a dad who killed his 19-day-old son because it wouldn't stop crying was allowed provocation because they said, oh yeah, the baby crying was things done to him, it provoked him, he can have the defence, which is obviously ridiculous. This case wouldn't be allowed now because it's not of an extremely grave character, doesn't give you a justifiable sense of being seriously wronged. Zebedee illustrates this further, where a defendant killed his dad because his dad was incontinent and kept soiling himself. He tried to plead loss of control and said, well, I lost control because he kept pooing his pants, basically. And you'll be happy to hear the defence was not allowed because his dad pooing his pants was not of an extremely grave character and didn't give the defendant a sense of being seriously wronged. Hatter tells us that the breakdown of a relationship won't be of extremely grave character or give you a justifiable sense of being wronged, and this issue will be decided objectively by the jury. The case of Clinton, massively important because it confirmed to us that you can't plead loss of control if your partner says that they've been cheating on you. So sexual infidelity alone can't satisfy a defence of loss of control. But in this case, he was able to plead loss of control because here she told him she'd been cheating on him and she'd also taunted him about his inability to commit suicide, which was of an extremely grave character and did give him a justifiable sense of being seriously wronged. So cheating or sexual infidelity on its own, not enough, but can be considered with other factors. The third requirement for proving loss of control is proving that a reasonable man might have acted in the same way. This comes from Camplin, where a 15-year-old boy killed a man who had raped him and then laughed at him. And the principle here was that the jury can consider the age and sex of the defendant when deciding would a reasonable man have done the same. And our final case on loss of control is Asmelash. And similarly to diminished responsibility, voluntary intoxication is not relevant when deciding whether a reasonable man would have acted the same. So I'll end here on the summary slide, which you may wish to pause to take notes from.